My name is James Hotchkis. I'm a member of the Council of the Scottish Law Agents Society. I am a practitioner with particular reference to private clients in a rural practice in the Highlands. My talk today is on succession and ethical issues, and some of the scenarios emanate from transactions I've had with clients in recent years. My first subheading is the need to have a client. I was appointed as financial guardian to an elderly Incapax gentleman in a care home. The gentleman subsequently died and funds were held by my firm in a special deposit account. Confirmation was not necessary to access the funds. In terms of the deceased's will, he had appointed two of his brothers as executors. One of those brothers had died and the other was Incapax. There was therefore no executor. The whole of the estate was left equally amongst the brother who had died, the brother who was Incapax, and a third brother who was also Incapax, and to the survivors and survivor of them. There was no provision for issue. Both of the brothers who were residuary beneficiaries had attorneys appointed to them and could therefore receive the necessary funds. The easy solution would be for my firm to pay the sums held to the attorneys for the benefit of the residuary beneficiaries. The difficulty, however, was that my firm did not have a client executor, and thus we were not able to disburse the funds to the attorneys for the two surviving brothers. In the circumstances, following advice from the Professional Practice Department of the Law Society, it was necessary for a nephew who was helpful to be appointed as intervener by the Sheriff Court for the purpose of later applying to the Sheriff Court as executor qua intervener to the estate of the deceased. The process of the summary application for appointment as intervener was lengthy and expensive, but had to regretfully be done. That nephew thus became our client in the winding up of the estate of the deceased. My next subheading is legal rights. What are the executor's responsibilities in regard to legal rights? Having advised the relevant individuals of their entitlement to claim legal rights, the executors are required to make available to those individuals or their agents the information which is required to enable such potential claimants to decide whether or not to claim legal rights. The minimum information an executor must provide to the potential legal rights claimants is A, the value of their legal rights entitlement, and B, the value of their entitlement under any will. The potential claimant does not need to see a full legal rights calculation as long as they have enough information to make an informed decision whether or not to claim legal rights. Following the case of the Law Society of Scotland versus David Haddo Campbell, there were the following findings. 1. There was clear judicial authority that legal rights have the nature of being a debt on the estate, and executors have a duty to pay debts. 2. Executors thus have a clear legal duty to inform a potential claimant of their entitlement. And 3, executors are personally liable if legal rights claimants are not informed. What happens if a potential legal rights claimant will neither claim nor renounce their claim? The matter clearly requires to be discussed in detail with the executors. If executors are content to accept the sum due to a potential legal rights claimant as sufficient to fulfill a legal rights claim, then solicitors acting for the executors will be able to accept instructions to pass those funds to the executors to be held on that basis. Agents should ensure that they have such instructions in writing, and it is clear to the executors that the funds are being paid over to the executors in their capacity as executors, and the responsibility that brings, and that the executors are clear that there is a personal liability attached to their positions. Additionally, agents should write to the potential legal rights claimant at their last known address and advise that agents no longer hold the funds to meet such legal rights claim. And if the potential legal rights claimant has any question in relation to his or her legal rights claim, he or she will at that point then require to contact the executors directly. Therefore, whether or not the executors disperse the legal rights funds without the claim having never been discharged will be a matter for them. The prescriptive period for claiming legal rights is understood still to be 20 years. Sale of a family home and intervening separation. I was acting for a married couple in the sale of their family home, with the title being held in joint and equal names and with no survivorship destination. Some days before settlement, the wife advised me on the telephone that there were marital difficulties between herself and her husband. She told me this had no bearing on the sale of the property. There was no separation agreement and no pre-sale agreement. What was my position? I consulted with the professional practice department of the Law Society, who were, as always, helpful. Basically, I had only been advised after the transaction was well down the line that there were any matrimonial problems, and I only received this information from one of the parties. My firm was not advising either of the parties in relation to matrimonial matters. My obligation in the circumstances was to divide the sale proceeds in accordance with the title 50-50 and to distribute the sale proceeds to the individual clients. The Law Society professional practice confirmed that that course of action was fully acceptable and indeed prudent. The Law Society confirmed that I was not being asked to provide any matrimonial or separation advice to either of the parties, and I was not given information by one of them which would require me to withdraw from acting. The Law Society therefore saw no problem with my firm continuing with the sale and bringing it to settlement and distributing the sale proceeds equally as in accordance with the title. Mirror wills. My firm was instructed in preparing mirror wills by a married couple, under which stepchildren of the wife, who were the natural children of the husband, were beneficiaries. Some 2 years later, the husband lost capacity. Following the husband losing capacity, and there being various disagreements between the wife and her stepchildren, the wife wished to change her will and effectively disinherit her stepchildren. Was I entitled to act for the wife in changing her will? On the basis that my firm had acted for both husband and wife in drafting mirror wills previously, and given the fact that it was now no longer possible for a mirror will to be drafted in similar terms, given the husband's loss of capacity, and in view of the fact that the wife was now looking to disinherit her stepchildren, my firm should not be involved in drafting a new will for the wife. The present circumstances were relatively easy to deal with for the reason that the original mirror wills had been drafted only perhaps 2 years before the wife wanted to change her will. Clearly, one needs to be aware that if one is instructed to prepare a new will for one party to a marriage or partnership, one should check whether or not the firm has previously acted on behalf of both parties to the marriage or partnership in attending to mirror wills. Unless you are advised that you have previously prepared mirror wills, that may be a difficulty. If wills are indexed under surnames, it may not be apparent in respect of parties who are partners and not married that there is indeed a mirror will at all. Obligations to other solicitors when a will is challenged. The Law Society Journal of July 2002, under In Practice Update, under the heading Executory Solicitors, Duties where Will Challenged, states, if solicitors are instructed by executors or are themselves executors appointed by the will of the deceased, they are entitled to proceed in accordance with the will until ordered not to do so by the court, unless they are aware from their own knowledge that the will is invalid. Solicitors do not require to cease dealing with the estate simply because they are advised that another party is seeking to challenge the validity of the will. In circumstances where my firm was advised there was a challenge to a will, but my firm was content that the will was valid, there was no difficulty with our firm proceeding in relation to the winding up of the estate, and in this case the sale of heritable property. Was my firm under any ethical obligation to advise these solicitors acting in the purchase of the sale of the heritable property that there was a challenge to the will? In the circumstances, our firm was satisfied the will was valid, and we were advised by the Professional Practice Department that there was no ethical obligation to advise the solicitors acting in the purchase of the heritable property on the potential challenge to the will. However, if asked by the solicitors acting for the purchaser whether there was a potential challenge to the will, we would obviously have to disclose its existence. In those circumstances, a failure to disclose the existence of the potential challenge in response to a direct question from another solicitor would put you in breach of Rule B1.14.1. Wills. When the name does not fit. In Brownrigg's Executor, Vindex Trustees Limited, Petitioner 2021, the Inner House considered the treatment of a legacy to a charity under a will where it transpired that the name of the charity was incorrect in the will. In this case, the deceased, who had survived her husband and had no descendants, left an estate worth about £1.3 million. The will provided for a legacy to a friend, with the residue to be divided amongst a political party and 3 charities. One of the charities was the Nelson Mandela Educational Fund, South Africa. Following the death, the executor had been unable to identify the charity by that name, and after investigation found a charity called Nelson Mandela Children's Fund, which was in South Africa. The executor proceeded to petition the court for directions as to whether a share of the residue could be made over to the Nelson Mandela Children's Fund. Without going into detail, the decision of the court was that while the intended charity had apparently been wrongly designed, it was perhaps a case where the executors could, inverted commas, see through, commas, the erroneous description and perceive the true identity of the intended legatee. If the executor was able to identify with reasonable certainty the correct charity, notwithstanding the misdescription, the executor could then proceed on the basis of using the executor's discretion in the management of the estate. The court concluded it had been reasonable for the executor to have made the petition to the court, and the court noted that the executor's intended course of action, paying to the Nelson Mandela Children's Fund, was fortified by having also sought the opinion of counsel. An executor should therefore seek appropriate advice to base their proposed actions, the duty to obtain and consider advice being a key one for executors. The court, in the circumstances, did not make any order directing the executors, but did allow the executors' expenses to be met from the estate. The outcome of the case places executors in a difficult and somewhat lonely position. In refusing to grant the petition, the court in many ways empowered executors and underlined the importance of their role as decision makers. In this particular case, the court considered it was appropriate to have petitioned the court, and the expenses in this particular case were charged to the estate. This may give some comfort to executors that in these more difficult cases, they should not rule out seeking directions from the court. Seeking directions will in itself be part of an executor acting carefully and prudently. But the decision also shows that in some cases the court does not consider directions are required, and in some cases the court could find the executor personally liable for the costs of the petition. It is not always easy being an executor. May I conclude by saying that many of the above matters will probably be well known to private client practitioners, but if anything, this may prove useful as a reminder. Thank you very much.